Hello, everyone. Welcome to Court with Krissy. I had a special request for a single ladies edition for the gentlemen, and while they don't put their marital statuses on the record, I have a feeling there's a few fixer-uppers available here. You better be handy, guys. I hope you like it. Court with Krissy is now in session.
Good morning, Your Honor.
Good afternoon. Are you Miss Sutherland?
Yes, ma'am. Or yes, sir, I am.
Miss Sutherland, do you understand your rights in court today?
I do understand my rights in court today.
Did you receive a copy of the 3 complaints?
Yes, sir, I did receive a copy of them. I did read them, sir.
So your first charge is obstructing official business, and the second charge is resisting arrest. Both of those are second-degree misdemeanors, which carry up to 90 days and a $750 fine. The third and final charge is persistent disorderly conduct, which is a misdemeanor of the 4th degree is charged. That's up to 30 days in the jail and up to a $250 fine. So do you understand all that?
Yes, Your Honor.
And how would you like to plead to those charges today, Ms. Sutherland?
May I please plead not guilty to obstructing official business?
You can plead guilty or not guilty to all or any of the charges. So you don't have to do all the same. You can do guilty or not guilty to each one of them. So you can do not guilty on the obstructing. What else do you want to? How do you want to plead the resisting?
I appreciate that. On resisting, may I please plead no contest?
You can. And then how about the persistent disorderly conduct?
May I please plead no contest on the persistent disorderly conduct?
Okay. So as far as the resisting and the disorderly conduct, a no contest plea does not admit guilt. However, it does admit the truth of the facts that have been alleged against you. Now, those facts are contained here in your court file, and I'll look through them in the form of police reports, any witness statements that might be out there. What's in these police reports that you're agreeing by nature of your no contest plea as being true, if those are enough to sustain those 2 charges, I will find you guilty. Do you realize that?
May I be please appointed an attorney?
Yeah, let's go ahead and do not guilties across the board. How's that sound?
Thank
What's your
you,
current
Your Honor.
address?
Sir.
Okay. What are you, 21?
Yes, sir.
And are you employed? Do you go to school? What do you do?
I have an ongoing crisis of coming to age, so I have had to take some time off to rehabilitate my mind and heal, but I'm an aspiring student and I want to go back to school.
Okay, what do you want to study?
I want to accommodate my strengths, and I'm figuring it out still, but I would love to do botany. I would love to grow things and create things personally.
Well, let me tell you what. I need to take a quick look here at the file before we make any decisions regarding your bond, so just sit tight for me, all right?
I understand. Thank you.
I ain't home yet for a year, bro. The 22nd, I'll get out for a year. I don't go see my kids, bro, with this slap. This one is when we saw bro getting on my stuff. It's just called the trailer, so you gotta do it legally.
Okay. Do you take medication?
I need medication, Your Honor.
Are you currently seeing a mental health professional?
Believe it or not, I've been attempting to, but unfortunately my coping mechanisms are not healthy at this time. And I'm trying my best to develop into a young woman and figure out how I can access probably doctors and counseling and more treatment for myself.
Well, here's what I'm going to do. I'm going to go ahead and release you on your own on your own recognizance, on the condition that you undergo a mental health assessment. What I'm going to direct you to do is, when you get out, you're going to call the Adult Probation Department of the Licking County Municipal Court, just because they will be able to give you contact information about who you can see. And to be honest with you, I don't know if they're going to be open by the time you get processed out, but behavioral health care partners, the old mound builders, they have a, for lack of a better term, a mental health urgent care on East Main Street, pretty nearby where you are right now. The social worker should know where that is, so you might want to ask them about that. You just pop in and say, if they're open, and say, I need an assessment because A, the judge told me, but two, because I feel like I need it. And they should be able to accommodate you. Do you have a medical card?
Yes, sir, I do.
Okay, so you should be in good shape in that regard. Now, here's what will happen with this case. Your case is going to be randomly assigned to a judge and set for a trial. Until and unless an attorney gets involved on your behalf, we're going to send notice to you directly at the address that's on your bond. Don't forget to include your apartment. Who else lives there, by the way?
My father.
Okay, so you live at home with your dad.
Yes, sir.
If you get a lawyer, all the notices will then go to the lawyer, so it's critical that you stay in close contact with them because their whole job is to get you the best possible outcome. So your job is to make their job as easy as possible by staying in touch. Don't miss any court dates, otherwise you get an arrest warrant and probably not an OR bond next time. So jail is no healthy place for anyone to be, let alone individuals who are suffering through some acute crises. So stop off at the urgent care once you get out today, and if they're closed, contact the probation department in the morning and say, the judge told me I had to get a mental health assessment for my bond. Can you tell me where I can go? All right?
And I have that written down.
Okay, very good. Well, Ms. Sutherland, do you have any other questions today?
I do. May I please have an public defender appointed to my
Yes,
case?
so you're going to go ahead and ask them for an application for court-appointed counsel. It's there in the jail, but since you're going to get out, it's your job to get it turned in, and it goes to the municipal court anyway. If you're unable to access the mental health urgent care today, when you come in tomorrow to drop off your application on the third floor, then you're going to go directly to the basement and just talk to a person from the probation department in person, and they'll point you in the right direction. Any other questions?
Yes, Your Honor. I have one more question. There was a intake of things that inmate property release that they had rejected. I was wanting to seek more information on if I was able to receive some of my things that are essential, like my phone. It has all of my
You should get
funds in
everything
it.
that they seized from you back unless they consider it evidence. And I know reading through the narrative report, the allegation is that you were holding what ultimately was determined to be a BB gun. I wouldn't be surprised if they held on to that, but like your phone and other personal possessions, they should release to you when you get out.
Your Honor, I do appreciate that because I intend to come back here tomorrow. I intend to turn in the form, and I appreciate you giving me an opportunity to prove that.
Well, you're very welcome, Ms. Sutherland. If you have no further questions, you may go with the officer.
Thank you, sir.
You have a good day.
You too.
All right, Officer Riley. That's pretty tame for Monday, and especially
I'll take it.
after the weekend of the gathering of the Juggalo.
Yeah, I was definitely expecting worse, so I'll take it.
You have a good day. We'll see you tomorrow. Of course,
Yep,
there's a
have a good
recess.
Yeah. Hello.
Hi, Ms. Wilkins?
Wilkes,
Wilkes.
yes.
I have it as Wilkins, Wilkins.
Wilks. ALICIA, middle initial L, WILKS.
Okay, Mr. McClellan.
I'll double check that and amend our information to reflect that proper name.
Wilkes, yeah.
Question 2. All right, but your first name is Alicia,
Yes, it is.
right? What's your date of birth? Mr. McClellan? Is there another Alicia Wilkins
Well,
in there with a
so-
different date of birth?
She was booked in as a Jane Doe
Ah.
and corrections.
Has there been a
And
fingerprint?
even the
done?
Lacey officer reached out to me over the weekend when she was booked and noted that the jail identified her as Alicia Wilkins, but he was trying to confirm that with different
Oh.
databases. So if she's given the name of Alicia Wilkes with a date of birth, I'll make sure we get the information there.
How fingerprint? What do we know?
No one confirmed with me how they.
I asked
There
them
would
to
be no-
fingerprint.
Pardon?
That, I asked them to fingerprint me and they said, no, I don't know. I said, well, I wanna go to court. Don't you guys have to fingerprint me and book me? And they said, no, I've been in there like with lice. They just now got me the shampoo. I haven't been outside. They haven't booked me.
You
I
talk
haven't
to
got a
Mr.
fingerprint.
Swinson here. I understand you've been in jail. So Mr.
Okay.
Swinson, Mr. McClellan, my concern is who do we have here and do we have the correct person that law enforcement picked up, whether the name matches or what, but is this the person that law enforcement picked up and on view to disorderly conduct under
Yes.
the Lacey Community Code?
Yes, it is.
Oh,
Okay,
I would believe so. Based on the booking photo, when that came in as a Jane Doe, it's been changed to Alicia Wilkins. And so that at least coincides with the report that the officer gave.
and it's an apparent consideration that yes, in fact, she was the person that was, but I think we need to find a good identity. So 'cause we have very different.
I was picked up on disorderly conduct. That was what they charged me with.
Yeah. You say your date of birth is.
And I've been in jail for at least 5 days and 5 nights.
She
They've
said
had
that's
plenty of time to fingerprint me. And I was just released from this jail about.
So what was your what's your date, what's your spelling of your last name again?
WILKS.
A.S. Wilkes. All right. All right. And Alicia, ALICIA.
Yes, ma'am.
Got a middle initial?
L for Lynn, LYNNE.
LYNNE.
Yes.
Okay,
I do see a person.
there we go. I wonder if. Are you looking up a? There she is. Okay. Have we had her here before? One down, is there anything else? with this one? Any more? That's the full record. Oh, there's more. Bringing the another case. No. Anything else? Oh, okay. And are you also known as Amber Lynn Jefferson in your
No,
past?
that was an
Nope.
alias I had like probably 5 years ago.
Okay,
I was
All
also
right.
known as Francine Miller, but that was in Multnomah County in
Ah.
Oregon.
okay, lots of different names. Well, you've been charged with this allegation of disorderly conduct under the City of Lacey Muni Code, and Mr. Swinson?
Yeah, Your Honor, this is an individual I didn't have a chance to speak with. I know she was not brought down to court yesterday. I'd be comfortable if Your Honor wants to go through the rights at arraignment, or I can do that if I'm given a breakout room.
Okay, well, I think I can probably go through that. So, Ms. Wilkes, obviously you've been before a court before, but I want to be sure again that you understand your rights and you have the right to a trial here in Thurston County, and you know
No,
that.
I've been here, Judge. When do I get to go to trial? I mean, is this arraignment again? So, I mean,
So
what
you
is the point of
understand you
this?
have the right to have a trial, and you
I have to
understand you have
have-
the right. You gotta just listen, and
I
then
am.
we can move forward. You can't push it along,
Okay, well, can I
unfortunately.
ask some questions at the end?
So,
Or-
sure. After we talk, yeah. So you have the right, to hear and question any witnesses that are called against you. You know that.
How am I supposed to do that in jail?
You're going to be released
Do you
today.
understand?
Okay,
You understand that you have the right to hear and to question witnesses that may be brought against you in a court case.
yes, I do. Can I just ask one
Okay.
thing?
No, no.
Okay.
We're gonna go through this and then I'll listen to your questions. You can't push
Okay.
this along. All right, and so do you understand that if you want people brought to court to testify on your behalf, you can ask the court to compel their appearance?
Okay,
Okay, and you're presumed not guilty of this charge. It's just a charge. It's just an
Okay.
accusation.
okay,
And you cannot be found guilty unless you decide to plead guilty or you're found guilty at trial. You know that?
okay,
All right. And at trial or at motions, you have the right to not say anything against yourself. That's the right to remain silent. You know that?
okay,
Okay. And let's say that you decide to go to trial, and that trial you get convicted. You have the right on that conviction to go to a higher court and ask for an appeal to make sure that everything was done right. Do you know that?
okay.
Okay. All right. I think that covers it. So you have a question.
So, I'm innocent until proven guilty?
Right, Ms. Wilkes, and I'd recommend that you not say anything about the specifics of this case. You are going to have an attorney assigned, okay?
Okay, am I getting out today?
Yeah, yes.
Okay. All right, thank you, Judge.
Be the agreement. So Mr. McClellan and Ms. Wilkes, I'm going to enter a plea of not guilty to this allegation.
Okay,
And Mr. Swenson, there's an agreement, there's enough evidence on probable cause.
Yes, Your Honor, I'll stipulate to probable cause for the purpose of today's hearing.
Okay. And then Mr. McClellan.
Yeah, I'm not asking that she remain in custody. The only thing I'd probably ask the court to consider, I know it's been a few days since the incident, but the concern is it did involve disorderly conduct being interfering with traffic, and law enforcement had to really work with her to get out of the roadway. And her behaviors were concerning, and I'd ask the court to consider having a DCR meet with her prior to her release, just given some safety concerns, but otherwise not opposed to her being released. No criminal law violations.
All right, and come back to court. So
I'm really
Mr.
sorry, Your
Swenson,
Honor. I'm really sorry.
Mr.
Let's
Swenson,
not-
let me talk to Mr. Swenson.
Okay.
Mr. Swenson?
No objection to her release, obviously, but I would object to the DCR review at this point, Your Honor. As counsel stated, several days have passed. I don't see anything concerning her physical safety or the safety of others based on her presentation today. So I don't believe that there's been a basis provided for that DCR review. And I'm concerned that because of the time that there wouldn't be one available to see her today.
So Ms. Wilkes,
Yes,
I'm going to release you on your promise to return to court and hand you a court date.
okay.
And
Can
that's
I
going to
just
be,
say- Can I just say, I'm really sorry. I was diagnosed bipolar and I was taking medication. I haven't been on my medication. And due to long-term drug use,
Wilkes?
recently I went to recovery and I don't do drugs anymore. But sometimes I get my appearance. I have to remember, that I'm not the only one in this world. And I'm really sorry. And I promise I won't let you know. I was in Oregon and Washington.
Ms. Wilkes?
I love
You're
as long as you don't violate the law and you come back to court, things will go well. All right. So, and take your medication if it helps you. So do that. So we're going to be back August 19th and we'll hand you notice of that. So you have to be back in court August 19th at 9:30 and just don't violate the law. Okay. Pacific Point. Okay. I think we got through that. So Mr. Swenson, I think we did it.
We did. Thank you, Your Honor.
Thank you.
Yeah. Have a good
I'll
evening.
see you
Ms. Lowe?
Yes, sir. Yeah. Can you
Okay, so we just need one of the attorneys for the city to log on to Zoom. Oh, great. Okay. Okay, so at the Nisqually Jail, is your name Jacob Lowe?
Yes, sir.
Thank you. So, Mr. Lowe, you're before the court today for a total of 4 cases, and they are cause numbers 24L1087, 1114, 24L1315, and 24L1383. The latter 2 cause numbers are on for arraignment. So cause number ending in 1315, you're facing arraignment on 1 count of theft in the 3rd degree. And cause number ending in 1383, you're before the court for arraignment on 1 count of criminal trespass in the 2nd degree, as well as obstruction of a law enforcement officer. The charges of theft in the 3rd degree and criminal trespass in the 1st degree are both gross misdemeanors, which means if you're found guilty, you face maximum sentences of up to 364 days in jail and a fine of up to $5,000. For the charge of criminal trespass in the 2nd degree, you face a maximum sentence of up to 90 days in jail and a $1,000 fine. And for the charge of obstruction of a law enforcement officer, you face a maximum sentence of up to 364 days in jail and a $5,000 fine. Do you understand all that, sir?
Yes, sir. Yes, yes, I do.
Thank you. Mr. Lowe, before we started this hearing, did you have a chance to speak with Mr. Carlo, the attorney on the screen there, about your constitutional rights?
Yes, I did.
If you had any questions about those rights, was he able to answer them to your satisfaction?
Yes.
Thank you. So, Mr. Carlo, I'll next turn to you.
And a very good morning, Your Honor. For the record, Luis Carlo for Ms. Lowe. The on-cause numbers 24L001315, 24L001114, 24L001087, and 24L001383. We will acknowledge receipt of the complaint, waive any further formal reading, ask the court to enter pleas of not guilty. On Ms. Lowe's behalf, I will note for the record that Ms. Lowe prefers female pronouns. Thank you.
Thank you for that information. And counsel, are you stipulating probable cause for purposes of arraignment?
We will, Your Honor.
Thank you. I will accept counsel's stipulation to probable cause for purposes of arraignment for cause numbers ending in 1315 and 1383. I'll appoint counsel to represent Ms. Lowe at public expense. I'll enter pleas of not guilty to all charges, and I'll next address conditions of release, beginning with the city, please.
Thank you, Your Honor. City had an opportunity to speak with law enforcement as well as the community court case administrator when we were having a little break there, because I do see that it looks like there have been a couple of cases for which the defendant has previously been referred to community court. The city's understanding also being that the defendant is not originally from this area, from Oregon. Sounds like the defendant's down on their luck, so to speak. I was originally going to ask for bail in these cases, given the short amount of time for which the defendant has been accruing criminal law violations in this area. That being said, and speaking with, again, the case manager as well as law enforcement, city won't object to release on personal recognizance. I would ask that the court order defendant to maintain law-abiding behavior, appear at hearings, notify the court if there's any change in address. I'm going to ask that the court order the defendant to abide by any trespass orders in effect, particularly with the Pierce County Parks Department. I'm also going to ask that the court order the defendant to stay out of the area of the Rite Aid in Lakewood where the theft is alleged to have occurred. Your Honor, because there have been prior referrals to community court, I would ask that the court do an inquiry with standby counsel regarding the viability of re-referring the defendant to that program. It seems like it might be a valuable resource for the defendant to take advantage of some of the opportunities available through community court.
I guess I haven't looked at the docket, but has Ms. Lowe already observed community court at this point?
Can always be referred after.
Yeah.
We accept referrals at any time, so.
The community court case manager represented that the defendant was supposed to be present yesterday to observe, but they don't recall seeing the defendant present.
I would ask the court to set this matter to the next community court date just for observation.
When is it? 26, what time would that be? Okay, so what I'll do is I'll go ahead and set this for community court observation on August 26th at 10 a.m.
Does that work for you, Ms. Lowe?
Yes, that's fine.
Okay.
So. And I wanted to clarify one thing from Mr. Gunderson. When you mentioned release on personal recognizance, would that be for all 4 cause numbers?
Yes, Your Honor.
Very good. All right, so what I'll do is I'll release Miss Lowe on her personal recognizance, which means you're promised to return to court. There will be certain conditions which will be as follows: appear timely to all scheduled court hearings, have no criminal law violations, update address changes immediately with both the court and Department of Licensing, use only your true legal name and date of birth, do not go onto the property or have contact with both Rite Aid in Lakewood, Washington, as well as the Pierce County Parks Department. Do you have any questions about those conditions? Okay, very well. And I'll note for the record that Ms. Lowe has nodded her head, indicating that she does not have any questions. So we'll set these for pretrials / community court observation on August 26th at 10 a.m. Ms. Lowe, does that date and time work for you?
Yeah, I believe so. Yeah, yes, it does. Can you hear me?
Yes. Thank you for that. I'm just filling out the order right now.
Okay.
Okay, I believe I filled out the order in its entirety, so I'll go ahead and sign it at this time.
Good afternoon, ma'am. What's your name?
Afternoon, how are you?
Sorry, what was your name again, ma'am?
Shalithia?
All right, Miss Shalithia Parker, correct?
Yes.
All right, Miss Parker, you've been charged with 1 count of criminal damage in the 2nd degree. Your bond for this charge is $4,000. You have a stay away condition to stay away from Taiwan, Dante Crum. You're not to return to your preliminary hearing is for September the 9th at 8:30 a.m. And in regards to court appointed counsel, you said you are working, but that it varies.
Yeah, I dance.
You dance?
Yes.
Okay, how much would you estimate the lowest amount you make per month?
I just started back. I was just going to school full time while me and him was together, but recently he just moved out. And I just started back dancing.
Okay, so you don't know how much you make per month? Or how much you start? What have you
worked like 2 weeks, you know, the first good, second week was slow.
Okay. I'm going to appoint counsel to represent you, ma'am. Do you have any questions?
No. And what did you say I was charged with again?
Criminal damage in the 2nd degree. It's been charged that you damaged the window of his apartment and his Volkswagen window.
The Volkswagen window?
It says you caused damage to the right side window.
No, I kicked the car. I didn't like.
Yeah, I'm just telling you what the warrant says. This is not a hearing at this time. So once you talk to your counsel, you can talk to them about if there's any defects in the warrant or any defenses you think you may have. Any other questions?
No.
All right, you're free to go. Thank you.
Mr. Jregier?
Yes, Your Honor.
Okay.
Apologies.
This is State of Kansas versus Kathleen Hutton. Case number is 20 TR 3100. If counsel would state their appearances, please.
Jregier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Kathleen Hutton, who does appear by video from the Butler County Jail. Your Honor, would announce at this time in this case on the amended information
My client would enter a plea of guilty to count 1, driving while suspended, Class A, non-person misdemeanor. States agree to dismiss count 2. There are agreed recommendations for the court at the time of sentencing.
Mr. Jregier, is that your understanding of the agreement?
Yes, Your Honor.
All right. The amended complaint is the one that was filed, looks like February 4th of 21.
Yes, Your Honor.
Okay. Ms. Hutton, have you heard what the attorneys have told me? You'll need to answer out loud, please.
Yes.
Thank you. I've been told that you're going to enter a plea in counsels at no contest or guilty.
Guilty, Your Honor.
Plead guilty on count 1, which is driving while suspended. That's after having at least one prior conviction for driving while suspended. That is a Class A misdemeanor. The Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Do you understand that?
Yes.
Okay. And is it correct that you're wishing to waive your right to a trial to enter this plea of guilty?
Yes.
Do you understand that while there may be recommendations to the court's not compelled to follow those recommendations?
Yes, sir.
So a person could be sentenced to the maximum that I just told you?
Yes, sir.
Has anybody forced or coerced you in some fashion to enter this plea?
No, sir.
Have you had sufficient time to discuss this with your attorney?
Yes, sir.
Are you under the influence of any medications or intoxicants, anything that makes it difficult for you to make sound decisions?
No, sir.
In regards to count 1, driving while suspended, a Class A misdemeanor, how do you plead? Do you plead guilty?
Yes, sir.
And on or about December the 25th of 2020, while you were in Butler County, Kansas, were you driving on a public roadway with a suspended license, having had a prior conviction for driving while suspended?
Yes, sir.
Okay. I do find that the plea is knowingly and voluntarily entered with the advice of counsel, of good counsel, and finds there's a factual basis, and I will find the defendant guilty of count 1. Count 2 is dismissed pursuant to the plea negotiations. I will hear recommendations at this time, beginning with the state.
Yes, Your Honor. Pursuant to plea negotiations for the sole count presently before the court, the state would be prepared to recommend a $100 fine, $108 court costs, while of course deferring to the court on the issue of attorney's fees. Count 1, as the state understand, is charged as a Class A, so there is the 5 days jail. The state does not object to the awarding of credit for time served, given that the defendant does appear before the court in the fashion she does today. State would further recommend, also pursuant to plea negotiations, a 6-month underlying sentence with 12 months of reporting probation, and a $6 probation fee, with that same probation being subject to all standard conditions.
Mr. Patterson?
Your Honor, we'd ask court to adopt the recommendations. In addition to that, I can tell the court her admission date into the jail is August 13. So on the 5-day issue, if the court adopts recommendations, she would still have a few days left to do.
All right. Ms. Hutton, is there any statements that you'd like to make before I pronounce sentence?
No, sir.
Ms. Hutton, looking at your record, the docket that they have me doing today is the expedited docket, and that typically has a lot of individuals who failed to appear in the past. And I'm looking at your the sheet on your case, and it reflects that you've had 4 times that you failed to appear on this case.
So I've tried to call Butler County and ask how to take care of it, and they tell me they don't know how to help me. I just need to know how to take care of it and what to do, and I will 100% do that.
Well, Ms. Hutton, I'm pretty familiar with what the procedures are, and when a person posts bond, which you've done, there's a date where you're supposed to be in court right on that bond sheet. And I have no doubt that that's occurred on your case. In fact, I can see some of them here in the file.
Yes, the a few days before I got arrested, that was out of my control. It really was.
Well, there's 4 times that you failed to appear, not 2.
Okay, well, I just need to know when to be to court because I didn't know when on the previous times, and I've called Butler County numerous times, and they tell me they don't know how to help me.
Ms. Hutton, how far in school have you gone?
I have a bachelor's degree in economics.
You have a college degree and you're saying you couldn't figure out how to make it to court?
I tried to take care of the ticket. I can get to court from now on 100%, sir.
Counsel, is there any concern that this individual has issues with competency or any other issues like we had with the prior person earlier today?
Respectfully, Your Honor, my understanding is that Mr. Patterson represents the defendant in these proceedings. I might respectfully defer to him on that particular issue.
Okay, Mr. Patterson.
Your Honor, I did have a conversation with her. It did not appear that she was not able to understand the legal concepts that I discussed with her. So I do not have a concern about competency. Her current, again, as I told the court, I tried to see her yesterday. She was in the infirmary. After a couple hours, they finally just said they weren't going to get her out of there to see me. Whether she has a medical condition that is keeping her distracted, that could be a possibility. But other than her mental health seems fine as far as I can tell, Judge.
All right. I'm going to interrupt this. I want to break out with counsel.
Yes, Judge.
With both Darren and Jared?
Yes. All right, we're back on the record now. I've had a conference with the attorneys. I'm not comfortable with the information, and I didn't want to broadcast information that might be private medical information, but I'm not comfortable with proceeding with sentencing at this time. Based upon potential medical situation there. I want to be sure that the defendant is clear-headed, doesn't have any issues there. I'm going to ask the clerk to look for a time on Judge Webster's docket next week, either Monday or Wednesday, as I understand, if there's any openings there, and continue the sentencing to that date.
And Jen, I don't know what your thought is on Monday, but I'm willing to put it in there and just deal with it, and we'll get through everything.
Okay, give me just 1 second.
And Judge, I apologize. I said I would appear anytime. I'm in an all-day trial next Wednesday and Thursday, so
okay.
Next Thursday afternoon.
Monday is pretty full, but we could probably squeeze her in.
Okay, can you give an idea of, I understand there may be dockets, Monday or morning or afternoon?
It'll have to be morning. It'll be 9 a.m. on the misdemeanor control.
Okay. All right. Ms. Hutton, I'm going to continue your sentencing to Monday, 9 a.m. on that docket. That's Judge Webster's docket. She's the judge that's had your case up till today. I'm concerned that, I've got some medical concerns, and I don't think I can really proceed with your sentencing. I'm going to keep you in jail. I'm not going to approve a bond based upon the history. So you'll continue to be held. You'll get jail credit for that applied to your case, no matter who's sentencing you. But I am going to continue to that time. Counsel, anything further at this point?
No, Your Honor.
One final point for purposes of the record, Your Honor. In light of the court's concerns and this matter being set over for sentencing purposes, is the court still finding that a plea has been successfully entered in this matter, or is the court finding that KSA 223210 concerning the same side of guilty or no continued pleas for good cause shown applies in this matter?
Well, at this time, I'm going to let the plea stand based upon what I've seen, heard. Obviously, there's a different standard. If counsel believes that it needs to be withdrawn before sentencing, Mr. Patterson's well familiar with that. I trust that Judge Webster, it can be brought back before me or in front of Judge Webster if counsel feels that is a situation if that's needed come Monday. But as of now, I'm going to leave the plea in place.
Yes, Judge.
Very good, Your Honor.
Thank you. So this matter is adjourned, and Ms. Hutton can be returned to her cell.
And Mr. Patterson, there was a lady at the jail. I don't see her now. Did we get that resolved?
She's on there, Judge, and that.
Oh, there she is. Okay.
That's Kathleen Hutton.
Yes. We are on the record in 2020 TR 3100, State of Kansas versus Kathleen Ann Hutton. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Kathleen Hutton. Ms. Hutton does appear from the Butler County Jail. Your Honor, in this case, it was initially heard by Judge Lee last Friday. Judge Lee did take a plea on the amended information to count one, driving while suspended as a second-time offender. The state had dismissed count two. As we were proceeding through sentencing, Judge Lee was concerned that there was a medical problem or medical issue, did not want to finish sentencing at that time, set it over for today for sentencing. I would tell the court, I've met and talked with Ms. Hutton here this morning. She does not have the issues she had last week, but she is very coherent, ready to proceed. I believe that we can accomplish sentencing here today.
All right. Recommendations for sentencing, Mr. Canfield?
Your Honor, the state would recommend a fine of $100, an 8-month underlying, suspended for a 12-month non-reporting probation. And there is the 5-day minimum. I would ask that the court grant jail time credit. My understanding in speaking to Mr. Patterson is that will satisfy that 5 days.
All right. Mr. Patterson, anything further?
The only thing is last Friday, the agreement was for a 6-month controlling sentence by plea negotiations.
And Your Honor, if the court wishes, I was the prosecutor on the
All right.
last hearing.
You're joining us for the state. Mr. Jregier, go ahead.
Yes, Your Honor. The state's understanding is that previously there had been an agreement reached on the issue of disposition, $100 fine, court costs while deferring to the court on the issue of attorney's fees, 5 days jail with credit for time served, as this is a Class A misdemeanor. 6 months underlying sentence, 12 months reporting probation, $6 probation fee with all standard conditions. The state does not have an objection to proceeding in that fashion. If indeed the court is comfortable proceeding sentencing, the state's understanding is that there were certain concerns raised by the court at the last hearing, although I think Patterson, or rather Mr. Patterson, has already addressed those far better than I can.
All right. And Ms. Hutton, what kind of work do you do?
Currently I am unemployed, but I have a very good work history. Normally at Quick Trip was my last job for 5 years, and bartending before that for 10 years.
Why are you not employed right now?
Because I have a ride issue. I did, but yeah, I just need to go fill out some applications. It's really easy for me to get a job.
Okay.
I can get a job very quickly.
Well, since you don't have a job right now and you've been in custody for how long?
Judge, she went into custody August 13th.
Okay. I'll go ahead and waive your attorney fees, but your fine will be $100 and your court cost will be $108. So you owe $208. Can you get that paid in 60 days, do you think?
Yes, ma'am.
All right, 60 days to pay. And your controlling sentence is 6 months. If you don't want to spend the balance of the 6 months in jail, then you need to be successful on non-reporting probation for 6 months. During that 6 months, you won't.
Judge, as an officer of the court, I just want the court to know the plea bargain was for reporting, but of course we'll leave it to the court how the court wants to do the sentencing.
And Your Honor, the state's understanding is that it was a 12-month reporting probation is what was previously agreed to as a part of plea negotiations. One thing I might also add, although this may or may not have any bearing on purposes of sentencing here today, is that the state did address on the record at the last hearing the possibility of KSA 22-3210 concerning withdrawal of plea occurring or at least applying in this matter. However, the court did decline to enter orders setting aside the plea, notwithstanding that count one, that based off my notes, guilty plea to count one was entered in exchange for a dismissal of count two.
Okay. Any reason to set aside the plea, Mr. Patterson?
We're not raising any issues concerning setting aside a plea, Your Honor. We're asking the court to complete the sentencing here today.
Okay, now, Mr. Patterson, you thought it was 6 months non-reporting. He says 12 months non-reporting.
No, Judge, I said
reporting.
6 month sentence. The plea bargain was for 1 year reporting.
Oh, okay.
And I wanted to be honest with the court about that.
All right, thank you. All right, I think I've got what the agreement and recommendation is. So your sentence is for 6 months in the county jail. And if you don't want to finish off the 6 months in jail, you need to report to probation for 1 year. And you have to do everything they tell you to do. It's going to be very important that you go to see them or you call them, whatever they tell you. They're going to give you a list of standard conditions, and you're going to have to follow those. You also have to pay, now with supervision, that's going to make it $268. Will 60 days still be enough for you to pay the $268?
Yes, ma'am.
All right, so $60 supervision fee added to that is $268 to be paid within 60 days. That's a condition of your probation. And I can't emphasize enough how important it is you report. And you don't change jobs, you don't change residence, phone number, anything without them knowing what you're changing it to before you change it.
Yes, ma'am.
You can make this as easy for yourself as you want by doing everything you want and getting it closed, or you can drag it out and make it a nightmare and end up in jail for 6 months. The other thing is there is the mandatory 5 days jail. And I give you credit for any time you've already served. If that only comes out to 4 days, you'll still have another day to serve. But if you've served 5, then you're done with that.
Yes, ma'am.
So anything else we need to address?
No, Your Honor.
If the court is ordering reporting probation be subject to all standard conditions, the state has nothing further, Your Honor.
All right, I am ordering all standard conditions. One other condition, Ms. Hutton, you must contact court services as soon as you're released from jail. You must either go to their office immediately or call them. And the jail probably has their phone number to share with you, which is your first communication once you're released is court services, or you'll be in violation right off the get-go. Okay?
Yes, ma'am.
All right, nothing further. We'll be in recess on Hutton. Ms. Hutton is excused.
Thank you, Your Honor.
Thank you.